my sweet tea. I realized I left it on the other side of the room. Yeah, I'm still in my PJs. No makeup, don't care. Welcome to No Crime, No Time. And we're going to be talking about the Stephen Avery case and the Court of Appeals denying Stephen on his post-conviction relief with no Brady violations found. And the question is there any hope? And I believe there is. Hidden in here is a little golden seed that we've got to look at. So I'm going to read it through, as I usually do. I try to refrain from commentary, but that doesn't always happen. I am on my phone because my computer's been hacked. I'm working on reformatting it. Let me see if I can find... I need the link sent to me, you guys, because it's on the phone I'm using. Abby 63, I am so mad. Corruption at its finest. I love you, darling. Not all is lost. There is hope. There really is. Okay, let's see. I believe... Who shared the link before? I saw someone share it. Jerome, did you share it? I believe you shared it. Let me see if I can get to you. I'll go to his page. Jerome on, ma'am, the French Wrecking Crew. I love you, my dear. Here it is. I'm downloading it. So, how do I view it? I'll download. Oh, let's see. What do I want to open it with? Whatever. Just open sesame. Let me grab another drink. This won't be as fluid as a read. First of all, it's a cold read, so. Second of all, it's on a phone with a cracked screen, so if I make a mistake, please be kind. I know I sound terrible. I've been up half the night, if not more. I'm actually excused from work today. My boss understands my feelings today. She was hoping for the best. Lisa Johnson says, I really thought it was going to be good news. Lisa, don't give up hope. As we read through this, there's one little part we're going to pause on for sure that explains there's a door open. Still, there's a window open. Okay? So don't lose hope. I know I'm very nauseous this morning. I've been sick to my stomach. I'm going to treat myself kind today. I want you to do the same. I want Stephen to do the same. We're not giving up. It's a battle. And sometimes we lose a very hard battle, but that doesn't mean the war is over, because this war is going to go on until we win. Court of Appeals decision dated and filed July 28th, 2021. Sheila T. Reif, Clerk of Court of Appeal. State of Wisconsin plaintiff respondent versus Stephen A. Avery defendant appellate. Appeal from orders of the Circuit Court for Manitowoc County. Angela W. Suckvisowitz. I'll try to say it again. Sucky titty witties. I don't know, some judge. Per curum, opinions may not be cited in any court of the state as precedent or authority except for the limited purposes specifically in Wisconsin Statute 809.23, subsection 3. Per curiam. In 2007, following a jury trial, Stephen A. Avery was convicted of first-degree intentional homicide, party to the crime, and possession of a firearm by a felon. We affirmed his conviction on appeal. The issues in this new case concern collateral proceedings, whether the circuit court erred in denying Avery's Wisconsin Statute 974.06, 2019 through 2020 motion, and 2 supplementary motions without a hearing, as well as his motion to vacate and for reconsideration of the first of these motions. We hold that Avery's 974.06 motions are insufficient on their face to entitle him to a hearing, and the circuit court did not erroneously exercise its discretion in denying the motions to vacate and for reconsider. Accordingly, we affirm. So I'm going to pause right there. What that basically means is that the court is affirming and confirming the ruling that there will be no evidentiary hearing of any kind, that there isn't enough to warrant it. Let me go back. I'm not going to do a lot of live chat reading because I want to get the reading done. It's like 48 pages. But I want to say good morning to everyone. Good morning, Lisa Johnson. Good morning, Nickelbacker. Overview. We previously summarized the facts of this case in our decision on Avery's direct appeal, see State versus Avery 2011. And we will discuss below those facts relevant to the collateral attack on his conviction. But for context, this case began in early November 2005 with the disappearance of Teresa Halbach. Good morning to you, Donella Hamilton. But for context, this case began in early November 2005 with the disappearance of Teresa Halbach, a 25-year-old professional photographer. Volunteer searchers found Halbach's RAV4 on the 40-acre site of Avery's auto salvage yard business, where Avery and other family members lived and worked. It was believed that Halbach had photographed vehicles at this time several days earlier, per Avery's request. According to the state witness, Bobby Dassey, Halbach was last seen walking towards Avery's trailer. After finding the RAV4, police searched the Avery property and over the course of the next 4 months, discovered and identified evidence including burned bone fragments in and around a burn pit, with DNA matching Halbach, both Avery's and Halbach blood in the RAV4, the remnants of electronic devices and a camera, the same model as Halbach's, and a burn barrel, Halbach's RAV4 key in Avery's bedroom with Avery's DNA on it, Avery's DNA on the hood latch of the RAV4 deposited, the state later claimed, by Avery's sweaty hands, and a bullet and bullet fragments in Avery's garage containing Halbach's DNA. The case was tried over a 5-week period in February and March of 2007. Like my throat chakra is closing off because this is choking me. It's hard to read. Just pausing for a minute. Okay. The case was tried over a 5-week period in February and March of 2007. The state's theory was that Avery shot Halbach in the head in his garage and threw her in the cargo area of the RAV4. He then burned the electronics and the camera, cremated Halbach in a burn pit, transferred the remains to a burn barrel, and hid the RAV4 until he could crush it on the Avery car crusher, or in the Avery car crusher. The defense argued that the law enforcement was biased against Avery, who was pursuing a wrongful conviction lawsuit against Manitowoc County and the Sheriff's Department, and as a result, planted evidence implicating Avery. The real killer, the defense argued, took advantage of this investigative bias to also plant evidence on the Avery property once early media publicity made it clear that Avery was a key suspect. The jury found Avery guilty of first-degree intentional homicide and felon in possession of a firearm. Avery received a life sentence without possibility of extended supervision. In 2009, Avery commenced his direct appeal by filing a motion for post-conviction relief pursuant to Wisconsin Statute 974.02 requesting a new trial. That motion was denied. Avery appealed, and this court affirmed in the aforementioned decision. In 2013, Avery filed Pro C Wisconsin Statute 974.06 motion, the 2013 motion, requesting a new trial. That motion was denied, and Avery appealed. That appeal was stayed and later dismissed on Avery's motion shortly after he initiated the post-conviction proceedings that are the subject of this appeal. In 2017, Avery filed the first of the 6 motions that are the subject of this appeal. These motions will be analyzed individually with further discussion of relevant law, but some basic principles apply generally. Wisconsin Statute 974.06 provides a mechanism for vacating, setting aside, or correcting a sentence once the time for direct appeal has passed, on constitutional or jurisdictional grounds, or where the sentence was in excess of the maximum authorized by the law, or is otherwise subject to collateral attack. Section 974.06, State v. Romero, Georgiana. Section 974.06, however, creates a procedural barrier to review in that it requires the defendant to raise all grounds for relief in his or her first post-conviction or appellate motion. State v. Bellette. Thus, a defendant is normally barred from raising issues in a 974.06 motion that were or could have been raised on direct appeal or in a previous 974.06 motion, State v. Escalona Novara. An exception to this rule exists where the defendant can show a sufficient reason for not raising the issue in the prior post-conviction proceeding. Whereas here, the defendant appeals the circuit court's denial of Wisconsin Statute 974.06 motion without an evidentiary hearing, then the question before us is narrow. Whether remand for a hearing is warranted because the circuit court erred in denying the motion on its face. See Bellette, Wisconsin. Pursuant, the court shall grant Pursuant to 974.06, the court shall, quote, grant a prompt hearing unless, quote, the motion and the filings and records of the action conclusively show that the defendant is entitled to no relief. Our Supreme Court has also determined, however, that a baseline level of specificity, I can't even, applies to all post-conviction motions, including those under 974.06. The state makes up words, the appellate court makes up words. Specificity. See bailout. Thus, in order for the reviewing court to meaningfully assess the claim, the defendant must allege sufficient material facts: who, what, where, when, why, and how. That, if true, would entitle the defendant to the relief he or she seeks. This requirement promotes finality once the defendant has been convicted and sentenced, minimizes time-consuming post-conviction hearings unless there is clearly articulated justification for them, and recognizes that the pleading and proof burdens have shifted to the defendant in most situations after conviction. Accordingly, in the context of a 974.06 motion, the defendant must describe with specificity he or her, I can't read this, his or her sufficient reason for failing to raise the claim in either. I can't do this today. This is just so depressing. I just feel gutted. I'm trying, you guys. Let's take a drink, clear the air. I'm going to hit a bell. Should have let it ring. Just clear the energy so I can read this. Accordingly, in the context of a 974.06 motion, the defendant must describe with specificity his or her sufficient reason for failing to raise a claim in any earlier proceeding. That is, the defendant must show why his or her claim is not procedurally barred under 974.06 motion. See Romero Georgiana. Y'all having a good time? Keep your chin up. We will further discuss some of the contours of this sufficient reasons exception below, but one point bears mentioning here. Ineffective assistance of post-conviction counsel can be and often is cited as the reason for the defendants not bringing some claim on direct appeal. The specificity requirement, however, applies just as much in this context. The defendant cannot merely present legal conclusions, similarly arguing that post-conviction counsel was ineffective for failing to bring the claims he or she now views as meritorious. Instead, to be entitled to a hearing, the defendant must raise sufficient material facts demonstrating prior counsel's ineffectiveness. That is, the counsel was constitutionally deficient, and that such performance was prejudicial to the defendant. I think my dog has to go potty. We'll finish this one paragraph. I'm going to take her potty and then come back and finish reading. Importantly, to show deficiency in this context, the defendant must allege sufficient facts showing that his or her new claim is clearly stronger than the claims post-conviction counsel in fact brought. Romero Georgiana. All right, guys, I'm going to leave it right there. I'm going to take Gretchen out to potty because she's got to go. She can't wait. And she's like, Mama, please. So I'll be back. Come here, baby. Come on. What? Thought you had to go potty. Want to go potty outside? What, you just want up? Okay, come on. Sorry, guys. Come on, baby. Let's take you potty anyway. I think that's your thing. My throat chakra is going. Make sure she's got her breakfast. And with water, please. I'm kind of distracted today. All right. Sorry about all that. Real life, you know. I'm not here to impress you. I'm just here to do the case. Okay. I love you guys, though. It's just me. Whew. Now I'm out of breath from doing the stairs that quick. There's a lot of stairs. My hair looks crazy today. Literally, what is this? You know, so far, I get where they're coming from. What they're basically saying is that you get one shot at this 976.04, right? You get one shot. You got to bring everything up if you're going to use this motion at once, so that it's not like you come in every time that you feel you have something to show to the court. I get that. Okay. But what I do not understand in this case at all is when you have affidavits of eyewitnesses coming forward and literally saying, I saw a completely different suspect pushing the victim's vehicle the night or morning before it's found towards this guy, the convicted person's home. What? What? Are you fucking kidding me? I'm sorry, you guys. Clearing the energy here. I'm about to smudge my room. My negative energy right now is really, really strong. I'm going to try to calm it. Here we go. Ready, guys? Hi, Ian. Odo Mobile. Charlie Unplugged's got tears. I know, baby. Just hold on. There's a little glimmer of hope in this. We're going to get to it. We're going to work through all 48 pages of this baloney. Whether the circuit court erred in not ordering a hearing involves two potential inquiries with separate strands of review. It is a disgrace. It is, Jennifer Manning, it is. Michelle Stratford, good morning to you, love. Margarita. Yeah, Charlotte Unplugged. Okay, I love you guys. Let's do this. The circuit court must hold a hearing where the motion is sufficient on its face unless the record as a whole otherwise conclusively demonstrates that the defendant is not entitled to relief. Whether Wisconsin Statute 974.06 motion meets the standard, including whether there is a, quote, sufficient reason for overcoming the procedural bar of Escalon and Novara, is a question of law that we review de novo. If, on the other hand, the motion does not raise sufficient facts, quote, or presents only conclusory allegations, or if the record conclusively demonstrates that the defendant is not entitled to relief, then the circuit court has the discretion to grant or deny a hearing. In such case, we review for erroneous exercise of discretion. Motion number 1, June 2017 motion. So this is the first Brady violation, I believe. In August 2016, Avery, now represented by counsel, brought a motion for post-conviction scientific testing. In November of 2016, the circuit court granted the motion, permitting Avery to conduct independent testing of 9 trial exhibits. 7 samples of blood-stained cuttings, swabs, or blood flakes taken from Hallbox RAV4 key, and a 1996 sample of Avery's blood. Blood flakes? Kind of like the blood flakes that Remaker collected on the night that they found the RAV. Well, they found the RAV in the morning. the blood flakes that were sprinkled on top of the carpet in the back of the blue RAV4. I'm trying, you guys. I don't even know where I am. Like, okay. Based largely. All right, a drink, and then we'll get going. I promise. I just, it's kind of like waking up and eating spoiled eggs and green ham. Based largely, I can't say it, based largely on the results of this testing and other investigations, Avery filed a Wisconsin Statute 974.06 motion in June of 2017, the June 2017 motion, requesting a new trial. His motion raises a number of claims falling into three categories for purposes of overcoming the Escalona-Navarro procedural bar. First, Avery alleges that trial counsel was ineffective for failing to fully investigate or present expert testimony in support of his theory that he was framed. Second, he brings several claims based on alleged Brady violations. Third, he raises claims based on the results of the new investigation of the bullet, the hood latch swab of the RAV4, and the RAV4 key, all of which he characterizes as newly discovered evidence. The circuit court found that most of these claims were procedurally barred under Escalona-Navarro because Avery had not alleged a sufficient reason for not raising them in 2013 motion or on direct appeal. The court further held that the claims based on the new scientific tests were considered in the context of the full record, did not allege sufficient facts that, if true, would entitle Avery to relief. See Romero Georgiana. The court noted that the new reports on the bullet, hood latch swab, and key were equivocal in their conclusions and ambiguous. Therefore, given the totality of evidence submitted at trial, it cannot be said that a reasonable probability exists that a different result would be reached at a new trial based on these reports. Accordingly, the court denied Avery's motion without a hearing. We review the sufficiency of this motion de novo. If we determine that Avery was not entitled to a hearing as a matter of law, we then review the circuit court's decision to deny him a hearing for an erroneous exercise of discretion, see identification, or CID. The first threshold step in this analysis is determining whether Avery had stated a sufficient reason for not raising these claims in the 2013 motion on direct appeal. Ineffective assistance of trial counsel. Maya, what are you doing? She's itching her leg, and she sounds like a Tasmanian devil. Avery's claims relating to effective assistance of trial counsel are not and cannot be based on new or newly disclosed evidence unavailable to trial counsel. Maya, she's deaf, so she can't hear me. Maya, yeah, she literally can't hear me. By definition, these claims are based on alleged errors of trial counsel, the argument being that Avery was thereby denied his constitutional right to counsel. As with any Wisconsin Statute 974.06 claim, Avery must show that there was, quote, sufficient reason that these claims were not raised on direct appeal in his 2013 pro se motion, see Escalona-Navarro, and to establish a, quote, sufficient reason is for not raising ineffective assistance of trial counsel claims on direct appeal. Avery must show that his new claims are, quote, clearly stronger than the claims post-conviction counsel actually brought. We begin by considering whether Avery has shown a sufficient reason for not having raised these claims in his 2013 pro se motion. We then turn to whether Avery has shown a sufficient reason for not raising these claims on direct appeal. It is at this point that the Escalona-Navarra analysis dovetails with the merits of Avery's ineffective assistance of trial counsel claims, because of its new claims are facially insufficient as a matter of law. Then post-conviction counsel cannot have been effective. No. Then post-conviction counsel cannot have been ineffective for failing to raise them on direct appeal. Therefore, after we analyze the potential procedural bar of the 2013 petition, we turn directly to whether Avery's remaining claims demonstrate a reasonable probability that, but for trial counsel's unprofessional errors, he would not have been convicted at trial. Sufficient reason for failure to raise the claims in 2013 motion. As a starting point, although Avery may argue ineffective assistance for post-conviction counsel as a sufficient reason for not raising these claims on direct appeal, that argument is not available to excuse failings in his 2013 motion. That is because Avery did not have a constitutional right to counsel following his direct appeal. As our Supreme Court recently observed, there is no constitutional right to counsel on a collateral attack, and consequently, the, quote, vast majority of Wisconsin Statute 974.06 motions are filed by pro se litigants. Hold on a minute. Pause for a minute. What? Talk about learning law. Listen to this shit. As our Supreme Court recently observed, there is no constitutional right to counsel on a collateral attack, and consequently, the vast majority of 974.06 motions are filed by pro se litigants. Why would you not? Why is it not our constitutional right to counsel on collateral attack? Hello, what? And that's just recently observed? Did they change the law? Some lawyer get on here and tell us what the hell's going on with the Avery case, please, that knows their shit. This doesn't seem right. I think we should have, I'm not trained in the law at all. I'm just a concerned citizen here. But don't you think it should be our constitutional right to counsel after we're convicted? First of all, just because we did things out of a timely manner, how does that affect whether or not this case could be turned over? It's like you've got this red tape going, but you forgot that justice has to do with somebody if they're innocent or not. I got to figure out where I was. Okay. Avery appears to recognize this point, foregoing any claim based on the mere fact that he was without counsel. Nonetheless, his June 2017 motion largely focuses on the quality of his self-representation, providing the following justification for not raising any of his current claims in his pro se 2013 motion. I can read those. Numerous unique circumstances are present here that provide sufficient reason the current claims were not previously presented. Mr. Avery had no way of knowing the factual and legal basis for the claims set forth herein. As a learning disabled indigent prisoner, Mr. Avery simply could not have known them. His attempt to file a meritorious pleading was thwarted by his lack of legal knowledge. The current motion is the product of over 1,000 hours of attorney time, hundreds of hours expended by private investigators, numerous consultations with experts, the expenditure of funds to retain those experts, and more. To expect an indigent prisoner acting pro se to compile a meritorious motion under these circumstances would be unreasonable. Mr. Avery's lack of legal knowledge, cognitive deficiencies, and the complexity of his unique case provide the sufficient reason that current claims should be addressed on the merits. Well said. Thus, we construe Avery to offer 6 somewhat overlapping explanations that, taken together, might provide a sufficient reason for not raising his claims in 2013. Number 1. He was unaware of the legal basis for the claims. Number 2, he was unaware of the factual basis of the claims. Number 3, he was acting pro se. Number 4, he was indigent. Number 5, he has a learning disability. And number 6, this case is particularly complex. These explanations do not justify Avery's failure to bring the majority of his claims. Again, the quality of Avery's representation in his prior motion cannot, in or of itself, constitute a sufficient reason for not raising an issue earlier. Accordingly, we reject Avery's first argument that he, quote, lacked awareness of his legal basis for a claim. Lack awareness of the legal basis for a claim is a term of art that does not merely mean that Avery was not a lawyer or lacked legal knowledge. Rather, it means that he could not previously have anticipated a change in the substantive law that opened up a new basis for a collateral attack. As to reason number 2, though, through number 6, Avery gives us bare bones factual conclusions, but does not meaningfully explain why the circumstances he described precluded him from raising most of these issues earlier. See John Allen, 274, Wisconsin. Regarding reason number 2, unawareness of the factual basis of the claims, Avery does not explain, and we cannot envision why he did not have all the facts necessary in 2013 to raise these claims, which, after all, are premised on the further investigation of evidence and witnesses known to Avery at the time of trial. See State versus Trollfree. As to reason number 3, as explained above, a defendant's pro se statute standing alone cannot excuse his or her failure to raise claims in Wisconsin statute 974.06 motion. Maya's driving me insane. Just a minute. Maya, I understand you're doing your little bath here. Yeah, I know, baby. Stop. It's a morning bath for you somewhere else. Maya needs a drink and to go potty. And some snack. Maya needs her cheesy. Call her down. Snack. Call her down with snack. No one's doing snack. All right, now the other dog followed me back up. It's a dog day. All right, lovelies, here we go. Oh, Maya didn't leave either, and she's spinning circles. She's so silly. With one exception discussed below, Avery's remaining reasons are similarly deficient. Avery simply claims that he has a learning disability and was indigent in 2013 and that his case is complex. He does not cite any law or develop any detailed argument as to why these facts alone or taken together explain his failure to raise these claims. It appears well established from federal habeas law from which we can borrow that reasons such as these are not the sort of grounds on which a procedural bar can be avoided. See Harry versus McAdory. Petitioner's pro se status, borderline mental retardation, and organic brain dysfunction did not provide sufficient cause to excuse procedural default of ineffective assistance claim. Cause must be based on an, quote, external impediment. So if the person is unable mentally to comprehend how to represent themselves. And they're seen as not having the constitutional right for counsel once you're gone through 12 people deciding your fate. The way the law is written looks pretty fucking bad. It makes it look like, if you don't know their red tape, it's not based on justice. It's based on, have you followed their rules? Did you get that timestamp on that document at that time? Did this person, it's all, the justice system is not turned into whether or not this person is guilty or not. It's turned into, do you know the law or not? And that way we can pay a lawyer. And if you happen to be not smart enough to know the law, you're screwed. So that means the poor people, no, don't start, Gretchen. That means poor people, people with less education, have a huge deficit in front of them. So that proves justice is absolutely not balanced at all. Because somebody that doesn't have the capacity to protect themselves should be even more protected, right? And after you've lost a battle and you are innocent, and we know that happens all the time, you no longer have the constitutional right for people to help you? Come on. We got to start changing some laws. We literally got to figure out which law it is. I mean, Norm Gone changed a law, right? And he got famous. So what do we have to do to write a law and get it passed? Do we just get, write the law and then get so many signatures and then get it before somebody? Similarly, like the American Disability Act. Thank you, Donella Hamilton. Rob Farrell. Okay, I want to read that. That was interesting to me. Margarita Hamilton says, at Rob Farrell, that is what I believe is at the root of this evil. Yeah. Yeah, so let's find out how we get a law so that you are entitled, you are constitutionally entitled to, let's change the law so that we're constitutionally entitled to counsel and after post-conviction. Let's get that law changed. How do we do it? Somebody teach me. I'll walk with you. I'll sign petitions. I'll share them. I'll work on it. 80,000, Nickelbucker says 80,000 wrongful convictions per year definitely happens a lot. Yeah, we need to work on this. I'm not kidding. We need to work on this. We need to get some laws changed. Because right now it's not focused on if anything Zellner's bringing up is true or not. It's focused on, did you bring it all up at once? It's kind of like taking your car in to a mechanic. And he's like, all right, you got one shot here to tell me everything you think is wrong with the car. Everything you think is wrong with the car. And you're like, well, check the brakes. Those seem like they're squeaking, and change your oil. And I think that's it. I really, really have been looking at this really hard, but I'm not a mechanic. I don't know. I just learned to drive. I borrowed the car. I don't know anything about cars. And then the mechanic's like, all right, okay, so you just want me to check the oil and check the brakes, right? Okay. Then the mechanic hands the car back and it breaks down the next day, and we find out the transmission was going. And the mechanic's like, well, I'm not fixing it because you didn't tell me it was wrong yesterday. And you're like, but you're the mechanic. You're supposed to know all this stuff. Why didn't you tell me the transmission's going out? Why am I fighting this? Well, I'm not helping you. The transmission went out. That's your fault. You forgot to tell me. I'm the mechanic. If you want me to fix it, you got to tell me what's wrong. We got to change laws, you guys. We literally have to figure out how laws are written. If Norm Gahn can do it, how do we do it? I mean, Ken Christ didn't even have to pass the bar to become a lawyer. State of Wisconsin, you don't have to. I wonder if I should just go take the bar test and see if I pass it. Maybe I'll just do that for fun, for shit and giggles. Hey, you guys, let's see how much it costs for me to take the bar test. I'll study for it. I'll figure out like the Wisconsin statutes and stuff. I did pass the auctioneer's test, which is a state test, very similar to the lawyer's thing. So then once I get that, maybe I can work on helping change the laws or something. That would be crazy to pass the bar. Does that make you a lawyer? I don't know. Be interesting, wouldn't it? All right, let's get back into this reading before my phone goes dead. Maybe that's what we need to do. Gretchen, are you wanting on the bed or something? Let me deal with Gretchen again. This is crazy. She doesn't do this lately. But last night and today, she's just crying. Up on the bed. There you go. I am so hungry for breakfast. Like I was sick to my stomach all morning. Ducky, I am gutted like everybody else. I know, Mary, I love you. I know. Okay. I don't feel like reading no more of this garbage, but we gotta pursue this. Okay. We're on section 22 if you're following along. The one exception we will recognize concerns Avery's contention that on his own, it would have been impossible for him to have undertaken the extensive investigation later carried out by current post-conviction counsel, which resulted in new theories as to how he was framed and additional factual support for previous theories. That's a good sentence. Let's reread that and savor it. The one exception we will recognize concerns Avery's contention that on his own, it would have been impossible for him to have undertaken the extensive investigations later carried out by current post-conviction counsel, which resulted in new theories as to how he was framed and additional factual support for previous theories. I like that, factual support. For example, if Avery believed that forensic testing would have shown that his DNA was planted on the RAV4 key, he could, of course, have raised that issue in his 2013 motion. But to do so with any chance of success, he would have had to allege that post-conviction counsel was ineffective for not raising an ineffective assistance of trial counsel claim on that basis, and to succeed on that claim. He would have had to show that this new claim was, quote, clearly stronger than those actually brought on direct appeal. See Romero, Georgiana. Absent forensic testing supporting the basis for such a showing, this would have been all but impossible task. Thus, quote, unique circumstance might exist wherein a pro se defendant is unable to perform or pay for an investigation, but later gains the resources to uncover new material facts and develop alternative theories of a crime, and on that basis can claim sufficient reason for not previously raising claims based on those theories. We do not perceive the policies underlying Escalona Navarra, namely the need for finality in litigation. The dogs are weird today. To prelude this result. Indeed, to hold otherwise could unfairly punish defendants who bring post-conviction motions based on all facts known to or reasonably discoverable by them. For Escalona Navarra purposes, claims based on newly conducted investigations which could not have been previously undertaken would appear to be little different than claims based on newly discovered evidence, and we will treat them as such in determining whether they are procedurally barred by virtue of Avery's prior pro se post-conviction motion. That said, Truth train coming through. Real life. That said, the majority of Avery's ineffective assistance of trial counsel claims are not based on investigations that Avery, now represented by counsel, was only recently able to perform. On the other hand, we have identified 7 claims, all premised on the results of forensic testing that could conceivably fall in this category. So I want to reread that. Something didn't quite click. I want to understand it, not just read it, understand it. That said, the majority of Avery's ineffective assistance of trial counsel claims are not based on investigations that Avery, now represented by counsel, was only recently able to perform. On the other hand, we have identified 7 claims, all premised on the results of forensic testing that could conceivably fall in this category. So as to address as nearly as allowable the merits of his motion, we will assume that Avery has alleged a sufficient reason for not raising these 7 claims in his 2013 motion. These claims are that trial counsel was ineffective for failing to, number 1, present a blood spatter expert who would have found that Avery's blood was planted in the RAV4. Number 2, present a blood spatter expert who would have found that Halbach was not thrown in the rear of her RAV4 after being fatally injured. And number 3, present a blood spatter expert who would have determined that the theory counsel presented at trial as to how Avery's blood was planted in the RAV4 was untenable. Number 4, present a trace material expert who would have found that the RAV4 key recovered from Avery's bedroom was Halbach's sub-key or secondary key. Present a DNA expert who would have found that Avery's DNA was planted on the sub-key by law enforcement. Number 6, present a DNA expert who would have found that Avery's DNA was planted on the RAV4 hood latch. And number 7, present a forensic fire expert who would have found that Halbach's body was not burned in the Avery's burn pit. Merits of Avery's claims of ineffective assistance of trial counsel. We now turn to whether Avery's ineffective assistance of trial counsel claims have alleged, quote, sufficient material facts, who, what, where, when, why, and how, that if true would entitle him to the relief he seeks. See John Allen. Bearing in mind that he is not entitled to a hearing where the record conclusively demonstrates otherwise, see Bellette. Avery must show that a hearing would not be frivolous. Avery cannot make this showing. First, he has wholly failed to demonstrate sufficient performance. The trial counsel's, quote, representation fell below an objective standard for reasonableness by counsel's not retaining experts similar to those he later retained. See Romero Georgiana. Avery apparently assumes that his findings speak for themselves and that, given the strength of his later claims, the necessity for such experts should have been obvious at the time of the trial. Avery also assumes, again without explanation, that any expert retained by trial counsel would have reached the same conclusions as his later experts. But even accepting these premises, Avery has not demonstrated prejudice that, quote, there is a reasonable probability that, but for counsel's unprofessional errors, the result of the proceedings would have been different. Avery's first 3 claims concern trial counsel's failure to retain a blood spatter expert. Avery argues in his motion that counsel was ineffective because such an expert would have found that, quote, his, quote, blood was planted in the RAV4. He retained experts' actual findings, however, are not nearly so conclusive. The expert did not conclude that Avery's blood, quote, the expert did not conclude that Avery's, quote, blood was planted, or rule out Avery as the source of the blood. Rather, he determined that the presence of Avery's blood was, quote, consistent with being randomly distributed from a source because his blood is present in some locations but absent in some other reasonable anticipated locations. And that, quote, the absence of blood stains in these locations is inconsistent with an active bleeder. The state alleged at trial that Avery's finger was actively bleeding while he was in the RAV4. The expert further determined that the blood stains were, quote, consistent with an explanation other than Mr. Avery being in the RAV4 and depositing his blood in those locations with his actively bleeding cut finger. Certainly, these conclusions tend to support Avery's general theory that he was framed, and their presentation may have been useful at trial. But Avery's burden in post-conviction motion is not merely to prove to helpful evidence, but to show how its introduction at trial could reasonably have led to a different outcome. See Strickland. He cannot meet this burden by misrepresenting the expert's results as, quote, demonstrating that he was framed. Absent additional facts or argument, we cannot assume that such measures support for Avery's frame of theory would have led to an acquittal. Next, Avery argues that counsel was ineffective because a blood spatter expert would have refuted the state's narrative that Halbach was thrown in the rear of the RAV4 after being fatally injured. Avery asserts that, to the contrary, Halbach, quote, was struck on the head after she opened the rear cargo door and was then, quote, struck repeatedly by, quote, a mallet or hammer without examining why an alternative finding as to how she was killed supports his theory that he was framed. Third, Avery contends that the blood spatter expert could have advised counsel that its trial strategy for explaining the presence of his blood in the RAV4 was flawed, i.e., that such a strategy would have failed to persuade the jury. This assertion is entirely speculative. As a matter of law, such guesswork falls well short of demonstrating ineffective assistance of counsel. I need to take a breather. I literally need to pee. Okay, I'm going to take a 5-minute. Do what you got to do. This is a very, very long read. It is what it is. I will be back in 5 minutes. I will make it lickety split. But I also need to rest my voice for a minute. And I just need to calm my energy. So, I'm not going to mute anything. You might hear the dogs wrestling on, but I think they finally have laid down. And I will be back in 5 minutes. All right. Thank you guys for waiting. This is abs. It was Abesto underwear because according to the bullet, this. Okay, what? Let me see chat for a little bit. How's everybody doing? TJ Anderson, good to see you. It was asbesto underwear because according to the bullet that supposedly killed her, she was made of wood. Mary says, KK, lot to answer for. Don't give up. Need you more than ever. Boy, things would sure have been different if Casey would have been Stephen's trial lawyer. I agree. Tammy Lee, I agree. Mary says, I read something last night. Purple thongs. Thought they burnt her. What? Yeah, Mary says, actively bleeding with gloves on. Hey, Slayer rocks. If they could reasonably have been carried out but weren't, doesn't this not support an ineffective counsel claim? I agree. Cobweb afternoon. Good to see you. Wow, I'm sorry to hear this. Me too. TJ says, Zelny's tweet, not deterred by the appellate court decision, if pointed out the specific doors that are still open for Mr. Avery's quest for freedom. We appreciate the careful review. Yes. We are going to find it. Go for it, Marriott Hamilton. Hey, Kind. Can you take the bar exam without going to law school? I don't know. I'm going to find out. Probably cost a couple grand to do it, but maybe I'll do it. Who knows? Maybe it's free. Who knows? All right. We've been at this for over an hour, so I suppose we should get busy. What page am I on? Does it even tell me? I'm on 19 of 49. My God, let's speed this up. It's hard to read all this. It really is. My stomach's just turning. I'm starving too. Like I was sick to my stomach all night. Now I'm hungry. Okay. I'm on section 30 if you are following along reading with me. Fourth, Avery argues that counsel was ineffective for not retaining a trace materials expert who would have found that the RAV4 key recovered from Avery's bedroom was Halbach's secondary key or subkey. But it is again completely speculative to assume that the subkey was therefore planted and not instead that Halbach herself was using a subkey and not her main key on the day of her death, except it has no DNA on it. But, you know, why would... Okay, we're going to stay on task. Section 31. Avery's fifth and sixth claims concern the retention of DNA expert. According to Avery, such an expert would have determined that his, quote, DNA was planted on the key by law enforcement. Avery again mistakes the evidence. His expert analyzed DNA from, quote, an exemplary key reported held by Mr. Avery as if to start a key, gripping by ungloved fingers for 12 minutes. The expert determined that the 10 times less DNA was deposited on the exemplar key than on the key recovered by law enforcement. The expert concluded that if the key was indeed enhanced, quote, tampered with, then it is likely that some personal item of Mr. Avery's was used for this purpose, such as, quote, a toothbrush or a cigarette butt. Thus, once again, the findings of Avery's expert are significantly more ambitious than what is presented in his motion. We have no reason to doubt the truth of these findings, although we note that the expert did not observe Avery holding the key, but simply determined that Avery deposited significantly less DNA in the controlled experiment does not indicate that Avery could not or did not deposit more DNA under other conditions, and it is certainly not demonstrated that the law enforcement planted DNA in the key. Thus, even accepting the truth of these new findings, we cannot conclude that there is a reasonable probability that their introduction of trial would have led to a different result. Section 32. Avery's sixth claim is that counsel was ineffective for not retaining a DNA expert who would have determined that the DNA from Avery's sweaty hands, quote, was never deposited by Avery on the RAV4 hood latch, demonstrating that, quote, Mr. Avery was being framed. In what is becoming a pattern, Avery has misrepresented the facts. The DNA expert Avery has now hired did not determine that Avery, quote, never deposited the DNA and did not state that Avery was framed. Instead, the expert performed a series of experiments on an identical vehicle wherein volunteers opened the car hood using the hood latch. Only 4 of the 15 volunteers deposited DNA, and those 4 deposited significantly less DNA than present in the swab from Halbach's RAV4 hood latch. From this experiment, the expert extrapolated the possibility that law enforcement could have retrieved and relabeled a swab of Avery's groin, which was collected and discarded for exceeding the scope of a search warrant, as coming from the hood latch. The expert admitted, however, that, quote, the convenience of this explanation and the fact that it accounts for the physical findings observed from the analysis does not prove evidence tampering, or more precisely, evidence reassignment. Thus, again, we are left with facts that, even if true, would not entitle Avery to relief. In a controlled experiment, the minority of volunteers who deposited sweat on the RAV4 deposited significantly less sweat than on the swab recovered by law enforcement. There is no context to these findings, no showing of why Avery, under non-controlled conditions, could not have deposited more sweat than the volunteers, much less any showing that the DNA was therefore planted. Without such context, this evidence is not exculpatory or even particularly relevant, and Avery's attempt to link it to the alleged reassignment of his groin swab is wholly unsupported by any facts of record. Avery's seventh and final claim is that trial counsel was ineffective for not presenting a forensic fire expert who would have found that Halbach's body was not burned in the Avery burn pit and that her bones were therefore planted. Avery's site factual support, once again, does not live up to the advanced billing. His forensic fire expert did state that he, quote, disagreed with the state's expert opinion that the main destruction of the body took place in the Avery burn pit. But Avery does not explain why, from his conclusion, it follows that Halbach's remains were planted, because he does not explain why himself would have been able to cremate some portion of Halbach's body in another location, including in his burn barrel, where additionally bone fragments were found. More importantly, Avery does not explain where or how prejudice arises, given that his own forensic anthropologist testified to the same conclusion at trial. Avery's expert further concluded that, contrary to the state's theory at trial, Halbach's body could not have been burned to the extent it was burned in only 4 hours. Again, this is a fact without context. At most, presenting such evidence on trial would have enabled the jury to weigh 2 competing expert opinions on how Halbach was cremated. Again, Avery has presented no reasoned bias for concluding that the outcome of the trial would have been different. In sum, the 7 ineffectiveness claims in Avery's June 2017 motion that are based on new investigations fail on the merits. Avery has not shown that the trial counsel provided objectively deficient representation by not hiring experts similar to those he later hired. Instead, Avery merely assumes that the need for such experts should have been obvious at the time based on the later findings of his own experts. In addition, Avery has not explained how these findings would have negated or undermined the cumulative effect of the other trial evidence. Thus, Avery has failed to show that even if all these findings were admitted at trial, the result would have been different. Consequently, Avery has not alleged sufficient material facts entitling him to a hearing on his claims of ineffective assistance of counsel. Brady violations. Longest read in history. Avery next argues that the state withheld favorable evidence in its possession in violation of Brady v. Maryland 373. He first alleges that the state suppressed a voicemail recording that Halbach left on the answering machine of her photography client, whom she met on the same day that she visited Avery's property. Next, he alleges that the state withheld an unedited video of the flyover footage of Avery's property and instead released to Avery an edited version, which is 3 minutes of footage. Finally, Avery argues that, quote, investigators concealed their knowledge that Halbach's RAV4 was driven onto the property of Avery's next-door neighbor. Avery does not claim that these alleged Brady violations were unknown and undiscoverable at the time of his 2013 motion or on direct appeal. He has given explanation for not raising any of his new claims in 2013 as general and relates to his status as a pro se prisoner litigant. His explanation for not raising his new claims on direct appeal does not reference the Brady claims. Thus, Avery has not overcome the procedural bar of Escalona Navarra by demonstrating a sufficient reason for not raising his Brady claims earlier. In any case, Avery's June 2017 motion does not sufficiently allege any Brady violations. Quote, a defendant has a due process right to any favorable evidence, material either to guilt or to punishment, that is in the state's possession. A defendant is entitled to new evidence based on the denial of such right by showing that 1, the evidence is favorable to the defendant either because it is exculpatory or impeaching. 2, the evidence was suppressed by the state either willfully or inadvertently. And number 3, the evidence is material. The standard for materiality is the same as under the prejudice prong of Strickland. Quote, evidence is material only if there is a reasonable probability that had the evidence been disclosed to the defense, the result of the proceeding would have been different. State versus Kevin Harris, 2004. Avery has not demonstrated any of the above elements for any of his claims, but what is clearest on its face is that this evidence, where it is even exists, is immaterial. Avery's first claim centers on the fact that on the day of Halbach's visited his property, she left a voicemail that she could not locate the residence of one of her other photography clients, whom she also visited that day. Avery argues that had this voicemail been played at trial, it would have refuted the theory that Halbach's final appointment was with Mr. Avery. At trial, however, the photography client testified that after Halbach left the voicemail on the client's answering machine, she found the client's house, took photographs, and left within 15 minutes. Then approximately 20 to 30 minutes after Halbach left, the voicemail was established through her phone records. Other witnesses' testimony placed her as driving to and driving on Avery's property. The voicemail is therefore consistent with the evidence, which is that Halbach left the voicemail, visited a client, and then visited Avery's property. There's no basis for the Avery's assumption that the content of the voicemail would have refuted the state's theory about when or how Halbach was killed. Section 39. Avery's next claim is that he received an edited version of the flyover video of his property that may have contained favorable evidence. As far as we can tell, this claim is based only on Avery's unsubstantiated belief that a second video must exist because the airplane was in the air for 4 hours, but the video he received was only 3 minutes long. There's no evidence of a Brady violation here because Avery merely speculates that evidence not even known to exist was suppressed. My throat's getting sore. Finally, Avery argues that investigators knew but did not disclose to him that Halbach's RAV4 was driven onto the property of Avery's next-door neighbor. It is difficult to follow this argument, but is based on an affidavit from the neighbor who does not state that the RAV4 was on his property, but rather attests to a conversation with law enforcement agents in which they stated their belief as to how Halbach's vehicle was driven onto Avery's property, presumably after Halbach's death, but the agents could have been referring to Halbach's driving route on the day of her death. Avery suggests that the information in the affidavit supports his claim that law enforcement framed him for the crime by driving the RAV4 through the neighbor's property and planting it on his. This argument is unintelligible, and in any case, we cannot perceive any Brady violation. There was no evidence here to suppress, and the facts in the affidavit are inconsequential. Section 41. Finally, Avery raises two claims based on newly discovered evidence. He contends that, quote, new scientific evidence demonstrates that the damaged bullet in Mr. Avery's garage was not shot through Halbach's head, causing her death. He also argues that, according to the new test results, the swab labeled as coming from Halbach's hood latch contained Avery's DNA was not, in fact, taken from the hood latch. In theory, a defendant should be able to more easily overcome the Escalona-Navarro procedural bar when basing claims on newly discovered evidence, which, after all, concerned evidence not available in prior proceedings. This is not the case here, however, as it demonstrated by simply turning to the merits of the Avery case. To obtain a new trial based on newly discovered evidence, a defendant must show that 1, the evidence was discovered after conviction. Number 2, the defendant was not negligent in seeking evidence. Number 3, the evidence is material to an issue in the case. And 4, evidence is not merely cumulative. If the defendant meets these criteria, then the circuit court must determine, quote, whether a reasonable probability exists that a different result would be reached in a trial. To be entitled to a hearing on post-conviction claims of newly discovered evidence, the defendant must allege sufficient material facts satisfying these elements. John Allen, 274, Wisconsin. Avery cannot meet one of more of these elements for either of his claims. As a threshold matter, he has not shown that his purportedly, quote, new evidence is in fact new. Avery asserts that the equipment yielding his test results was, quote, previously unavailable, was, quote, new technology, and or was manufactured in 2016. But aside from these cursory statements, Avery does not address whether technology available at the time of trial could have yielded the same results. Beyond that, Avery's evidence is largely irrelevant. The premise of his first claim is that if the damaged bullet found in the garage did not deliver Halbach's fatal shot in the head, then he could not be the perpetrator. The state never argued that either of the bullets recovered from Avery's garage killed Halbach. At trial, the state showed that Avery's gun fired the bullet and that the bullet had Halbach's DNA on it. But the state did not argue that the specific bullet entered Halbach's skull or killed her, nor was it necessary that it do so in order to implicate Avery in her murder. There's nothing to suggest the shots fired into Halbach's skull were the only shots fired at her, or that every bullet fired at her contained skull fragments. There were, after all, 11 casings and only 2 bullets found in the garage. The presence of Halbach's DNA on a bullet found in the Avery garage is particularly damning evidence, regardless of whether it was the bullet that entered her skull, and strongly implicates Avery's absence evidence that Halbach's DNA was planted, a supposition that even now Avery has done little to develop. At the very least, Avery's new evidence, if it is in fact new, is consistent with the state's theory of the crime. Avery next argues that the expert observed the hood latch swab and determined that, quote, swabs collected from the hood latch of two exemplar vehicles, a 2012 RAV4 and a 2007 Volvo S60, each showed a considerable heavier loading of debris than the swab from the RAV4 hood latch. The expert apparently reached this result, however, by observation alone, concluding that whereas particles on the RAV4 hood latch swab could only be seen with the aid of a microscope, a swab from each exemplar vehicle showed a heavy dark streak of collected debris that is clearly visible to the unaided eye. We are left to wonder how new testing methods or equipment could possibly aid this analysis. In any event, the expert did not determine that the purported RAV4 swab, quote, was not used to swab the hood latch, as Avery claims, much less that this swab was reassigned or otherwise used to frame Avery. There is no possibility that the presentation of this evidence could have yielded a different trial result. Conclusion as to the June 2017 motion. Because Avery has not shown that he is entitled to a hearing on any claim, we review the circuit court's denial of a hearing for an erroneous exercise of discretion. See Romero Georgiana, we find that the court did not err in this regard. We agree with the court assessment that had Avery's equivocal and ambiguous conclusions have been introduced at trial, there would have been no reasonable probability of a different result. The circuit court appropriately exercised its discretion. We've given Avery the benefit of several doubts as to why he did not raise these claims earlier, even considering on the merits and the claims asserted in his June 2017 motion are speculative, conclusory, and in some cases misleading. The circuit court did not err in denying these claims without hearing. Okay, I'm going to stop here for a few minutes, and I will come back this afternoon to conclude with motion 2 forward. We are on page 28 of 49, so this video I need like a lengthy break. We will come back for those of you that are interested in continuing with the actual documentation. We will start with motion 2, and again, it will be page 28. So let's just stop that for now. Let's see. Let's set a time to do this. What do you guys feel for a time? Like an hour? I'm exhausted. I haven't slept. Oh. Because we can come back and watch this. I need to get food in me is what the deal is. We're going into motion 2. All right. So I will close off this live. This will be part 1 of this reading on the Court of Appeals ruling. There is hope. Don't lose hope. There are some things being called out here, and we're only addressing one thing right now. You know, yes, we're addressing a lot, but I mean, there is other avenues to pursue this. So don't lose hope. And if you do care to join me, I will be back in about an hour, give or take a few minutes. And it will be part 2. We will start with motion 2 on, and if you're following along, it is page 28. All right. I love ya. To the moon and back. Stay strong. Stephen, we're there for you. We're there for you.